Good afternoon. My name is Yavar Hameed. I'm a human rights lawyer based in Ottawa. I'm here to deliver a statement regarding an important historical case that will take place tomorrow in Ottawa. It is led by the Legal Centre for Palestine, which is the lead partner in the Coalition for Canadian Accountability in Gaza, along with the International Centre of Justice for Palestinians and independent lawyers, Dimitri Lascaris, and myself. The other lawyers on our team are Shane Martinez, Jouman Al-Asmar, and Asaf Rashid of the ICJP. The coalition filed a lawsuit in Superior Court 1 year ago on behalf of our clients, two Palestinian Canadian men, Hani al-Batniji and Tamer Jarada, who have suffered unimaginable losses as a result of Israel's genocidal campaign in Gaza since October 2023. Importantly, this case is not about the harm that Israel has caused. We sincerely hope that Israel will face the justice that it deserves at the international level, but that is not a matter for the Superior Court of Justice. This case, brought in a Canadian court under Canadian law, is about Canada's liability for what it did and did not do as its ally, Israel, committed horrific acts that harmed our clients. The case is about what is being tolerated and tacitly supported by our government in our name as Canadians. It is about the fact that this country's respect for the rule of law and human rights have been significantly diminished by our government's loyalty to a foreign state that practices apartheid and engages in genocide. Many Canadians are beginning to wake up to this dark reality. As citizens, we have legal tools at our disposal to hold our government to account. Under Canadian law, Canada has a duty to adopt measures to prevent genocide where it has knowledge about a risk of genocide. We will show that Canada had early and consistent knowledge about the risk of genocide in Palestine over the last 2 years. With that knowledge, any law-abiding state would have taken some immediate steps. Our lawsuit lists things that Canada could have done, but didn't do, if it were actually serious about fulfilling its legal duties. It could have imposed sanctions, terminated arms deals, ended military cooperation, prosecuted Canadians who travel abroad to fight, extracted Canadians from Gaza, and accelerated family unification for Canadians with relatives in Gaza. Any of these measures, and certainly all of them taken together, could have satisfied Canada's legal obligation to restrain and mitigate the impact of Israel's assault on Gaza. Canada's failure to act cannot be reconciled with its common law duty to prevent and punish genocide and its charter duty to not threaten the life, liberty, and security of the person of any Canadian anywhere in the world. The remedy our clients seek from the court is a declaration that Canada has breached its legal duty to prevent genocide in Gaza. The declaration of this nature would be highly meaningful, not only to our clients, but to many Palestinian Canadians who have been personally impacted by events in Gaza and left heartbroken by Canada's abandonment of its values and its condemnation of Israel's genocide. The question of whether Canada's inaction gives rise to liability under Canadian law for failing to prevent genocide is not only a valid legal question, it's an important question in the public interest and one that deserves an answer. This case is not just about two clients, it impacts the interests of the entire community of similarly situated individuals. It has implications for all Canadians. It needs to be heard and judicially determined. Yet instead of accepting the jurisdiction of the court and arguing its case on the merits, the government has instead forced our clients to fight for their right to be able to make their case. The government has called our client's case a waste of time and has asked the court to throw it out without even a chance to be heard. Our clients are not nuisance litigants. They are not operating in bad faith. They do not seek special treatment. They want access to justice. They want their day in court to have a judge decide the legal issues that matter to them. We will be in court tomorrow arguing that Hani and Tamer are not wasting the court's time and are not unnecessarily burdening our judicial system. At the core of this case lies a fundamental question. What is a state's responsibility to prevent genocide? This question is not abstract. It goes directly to Canada's actions and policies, to the ways this country has supported Israel, even as Palestinians in Gaza have been bombed, besieged, and starved. Canada knew Gaza had been under a crippling Israeli military blockade since 2007, a land, sea, and air blockade premised on collective punishment. It created what remains an open-air prison marked by extreme poverty and unemployment. It knew, or ought to have known, that between 2008 and October the 6th of 2023, more than 3,800 Palestinian civilians were killed by Israeli forces, and that Palestinian civilian deaths outnumbered Israeli civilian deaths by more than 21-1. In this period, over 153,000 Palestinians were injured. Canada also heard at the outset of this invasion in Gaza, Israel's defense minister, Gallant, tell troops on the Gaza border that he had, quote, released all restraints and removed every restriction, declaring ominously that Gaza won't return to what it was before. We will eliminate everything. And yet, while Gaza was being bombed, Canada authorized record exports of military goods to Israel. Tens of millions of dollars in previously and newly approved arms were authorized in October, November, and December of 2023, even as civilian casualties soared and even as the UN issued genocide warnings. At the same time, Canada imported more than $32 million in weapons from Israel, including Spike missiles from Rafael, Israel's state-owned weapons manufacturer. By late October 2023, the world already knew what was unfolding. Israel had imposed a complete siege, food, water, fuel, electricity, all cut off. Hospitals destroyed, aid blocked, entire communities erased. The United Nations and the International Court of Justice warned that genocide was imminent. I personally delivered formal notice of this crisis to Canadian officials standing at a press gallery here in Parliament Hill in November of 2023. Canada knew, and it failed to act. Worse, it continued military cooperation, authorized arms exports, and granted charitable status to groups funding Israel's military. In doing so, it failed its legal and moral duty to prevent genocide, the crime of all crimes. It failed Hani. It failed Tamer. Tomorrow, the Superior Court will hear whether the rule of law extends to the actions and omissions of our government, actions that helped foster the conditions for genocide. As the suffering in Gaza continues long after the so-called ceasefire, and as the machinery of oppression and starvation grinds on, we stand as a coalition of conscience demanding an end to the hypocrisy of a government that claims to uphold human rights while enabling their destruction. Canada says our case is doomed to fail. We have a different view. We believe we are all doomed if we quietly accept the inevitability of our own government's participation in the most horrific crimes of our generation. Thank you.
Thank you. There's currently no question. That will end the press conference. Thank you. Merci.